All right, guys, welcome to the second video in our family forms training. In this one, we are going to focus on communication and client interviewing. The first thing we're actually going to talk about is legal advice versus legal information. And I know at least one of you out there is thinking, wait, what does this have to do with communication? But every single thing you say to the clients, you want to be conscious of what you're saying and making sure that you are not accidentally giving legal advice. Legal advice can only be given by a lawyer. If you are not a lawyer and you give legal advice, you are practicing law without a license. That's not a good thing. We don't want that. Really important for our clinics that we are able to stay in the legal information side of things, not the legal advice side of things. So, what is legal information? What is legal advice? Let's start off with legal information. This is the good stuff, the stuff that you can provide in our clinic. So, legal information, here's how I think of it as a general rule. Something is legal information if you would say it, and it would be true, to any person who came through the clinic. So think about that idea. We'll talk about it a little bit at the end of this slide as well. So some examples of legal information. General information about the forms. So if I say to you, a stipulation is used to change an order when both parties agree 100% about the change and are both willing to sign the form. That is just information, right? That is just as true if I say it to you as if I say it to the next person in line, as if I say it to any of the 100 clients we have seen in the last couple of weeks, right? Now, some of our clients might say, that's a lovely piece of information, but I'm here for a divorce, right? So it may not be relevant to them, but the information is still true. Similarly, when you're talking about what a section of a form is asking for. So if you say, on this line, it's asking for the date of your last court hearing, or on this line, it wants us to put the specific amount of child support that you're asking for. That is general information. Again, no matter who you're talking to, if you say, this line is asking for the date of your last court order, that is true. The person may wonder why you're talking to them about a form they're not interested in, but the information you have provided is just information because it's true no matter who you say it to. There's no real analysis involved. You're just giving them a fact about the form or a fact about the process. Another thing that is included in legal information is procedural information. So if you tell someone or I tell someone to file this modification motion, you're going to start in room 104. To get a court date, you need to go to room 707. That is just procedural information. That is true for every single person I talk to. No matter who I talk to, if I say to file a modification motion, you start in room 104. That is true. That's just a general piece of factual information. You can get a copy of your arrears balances in room 101. Like if you're telling somebody where they can find something, it's all procedural. Again, think about it. It's true no matter who you say it to. The last bit here is where some students get in trouble, so use caution with this last one. Very, very common sense. So some of you are going, well, I think it is common sense that somebody should ask for $1 million a month. No, I'm not talking about specific things. When we're talking about very, very common sense, sometimes you're going to get somebody who wants to call the judge a butthead, or quite frankly, who wants to use profanity to describe the judge. It is okay to say, usually in legal documents, we don't use profanity to describe court officials, right? So that's what we mean by common sense. So not like, I think it's common sense to file your taxes on this date. I'm not talking about that. We're talking about very much, yes, you think the judge is a narrow-minded butthead, but we can't use that language here, right? Or if somebody says, well, I would, I think I'm going to call my ex Dr. Pepper, even though that's not their name. I just think it'd be fun. You could say, well, it's your form, but usually we don't refer to a person by a random soda name. We usually use their normal name, right? So that's what we mean by very, very common sense. So be careful with that one because there is going to be something where you're like, aha, this I think is common sense, and I would not describe it as very common sense. We're talking about just, again, Of course, you could put the script to Star Wars in this section, but that seems like an odd choice, right? We're talking about things where it's just so unusual that you're going, just so you know, generally, this isn't what we would be doing. So be very careful with that one, but it is true that some of that can be legal information. So, going back to my rule, it's legal information if you would say it to anyone and it would be true. It is just a general fact that you are providing, folks. Sometimes that line can be very difficult to see, so keep that in mind as we move on and we talk about legal advice. So, legal advice, which is stuff we cannot do, is what is going to happen when you are analyzing someone's specific situation. So, legal advice, being the opposite of the legal information we just talked about, is where it is not true for every single person you talk to. In fact, it would only be true for the individual that you are speaking to, because you are analyzing the facts of their specific case and drawing conclusions or otherwise making assumptions. So, what are some examples of that legal advice? If you tell somebody what they should say or do in their motion, and this is going to be so hard because you're going to see there's a section on the form where it says, what's the substantial change? And your client's going to turn to you and say, I don't know, what do you think I should put? And your impulse as a helpful human being is going to be to say, aha, I should tell them what to say. Like, I can't tell you how many times a student comes up to me and says, hey, what should I tell them to say? And I'm like, legal advice, man. So just keep in mind that telling someone what they should say or do in their motion is advice. So if I say, for example, you should say that you should ask for placement because your ex sounds like they're a jerk or they're a threat to your kids. I have given you advice, because think about it. If I say that to client A, I say, you should ask for placement because your ex sounds like a jerk. That's true for them. I am analyzing what they have told me about their ex. I'm drawing the conclusion that that person is a jerk, and that because that person is a jerk, the children should be placed with the parent that's with me. I am analyzing their situation. If the next person comes in and I say, it sounds like you should have placement of your kids because it sounds like your ex is a jerk, they might be like, what are you talking about? My ex is great, and the kids actually live primarily with my ex. I'm here about child support, right? It's not true from person to person. So think about our examples from legal information. File this motion in 104. That was true no matter who I was talking to. Again, it might not be relevant to the person I was talking to, but it was true. Legal information, this analysis where I say, hey, you should do this motion. I'm sorry, it keeps bringing up the info about my mouse. You should do this motion because your ex is a jerk, because whatever our reasoning for it, that is putting you into the legal advice line. Here, when you tell somebody what will happen in their case, so again, you are analyzing what you think will happen. You're making a prediction. So like, yeah, the judge is definitely going to give you what you want because it sounds like you really need it, or what have you. That is advice because you have analyzed and you've predicted what's going to happen if they take a specific path. And I know some of you are going, well, that doesn't feel like advice if I'm just telling them I think it's going to work. But it is advice because you're saying this is going to work is guiding them down this path, right? So they're sort of going, oh, you think it's going to work, so this is a good idea. I should do this. And so it becomes as if you told them they should do this because it's going to work. So again, if I say, yeah, this is probably going to work because it sounds like you really need support, that is giving advice. And again, anytime you analyze facts or apply rules to the facts, and so I gave sort of a really obvious example here, but under the statute, the substantial change in circumstance, right, that's analysis. So you said this, that is clearly a substantial change because this. I am analyzing their specific situation. And as I always said, this rule of thumb, the easy way to tell is if you said this to another person, would it still be true, right? If I said to somebody else, hey, you're definitely going to get this because your ex is from, Mars, and Martians can't have placement. Or your divorce is probably going to be done in 60 days. Like, think about that. Would that be true if you said it to the next person? If the answer is no, it is probably legal advice. And for those of you who've listened in order, it is my periodic moving my cat away from my computer. All right. So we've done legal advice, legal information. I've got just a little practice example here for you. So if you want to read through these quick, if you want to pause the video so you can do a quick minute to read through these examples and to see what you think each of them is going to be, we'll have you do that. I'm going to go ahead and just hop to the next one, so we won't sit in silence, but do read through them and see what you think your answers will be. And let's go through these real quick. So the first one, in a divorce case, the summons and petition need to be served on the other party within 90 days. Sometimes that phrase, need to be, throws people off and they say, oh, that sounds like advice because you're telling them it needs to happen. But here it's just stating information. So again, think of that rule of thumb. This would be true no matter who I said it to. It is just a fact about the process for divorce. It needs to be served within 90 days. Here, this one also throws people off because they're like, it's just a calculation, But 90 days from the day you filed your case was June 10th. It is analysis, right? I am taking the facts of their case, the date they filed, I'm adding 90 days, and I'm drawing a conclusion. This date is the 90th day. So I know that sounds silly, and I'll be honest, that one is one that is difficult in our clinics. We have to work around it, but it's challenging for sure. But that is technically advice. And again, if we go back to our rule of thumb, think about it. If you said this to the next person, they would say, what are you talking about? I filed my case July 19th. How could 90 days be June 10th? If I say today is August 19th, that is just general information. Great news. Yeah, I mean, that's again, it's a fact. I can say that to anyone who comes in and it's equally true. Your toast, dude, is obviously drawing a conclusion. I don't know that it's the most sophisticated analysis, but you're drawing a conclusion. You're saying this isn't going to work. So, and that's sometimes something you kind of have to be careful about because your little side comments where you're not meaning it to be guidance, but it can feel like guidance to the clients. If you have the food share app on your phone, we can approve the fee waiver down here. That's just factual information. Again, true for every person we could say it to. Everyone has to fill out this section, even if you and your spouse have already split up your stuff. This one often trips people up and they say, well, it's that even if you're analyzing their situation, right? I'm actually not, right? It is true. Everybody has to fill out this section. That's true. And you have to fill it out even if you and your spouse have already split up your stuff. That's also true. So it's just factual information, even though the situation where I'm saying, even if you and your spouse have already split up their stuff, maybe in response to a client saying this, you should ask for maintenance because your spouse makes so much more money than you do. That's analysis, right? So if I say that to person A, they would go, yeah, you're right. If I say it to person B, they're going to say, what are you talking about? My spouse makes less money than I do. So it's not true for everyone you say it to. If you plan to work with our clinics, you don't need to buy the Part 2 paperwork because we provide it for free. Factual information. That sounds good. This is such a tricky one because it's those little throat clearing things that you say when you're interacting with somebody to buy time because you're trying to type. But that sounds good is sort of that confirmation. What you said sounds good. It's akin to, I think it will be successful, right? And you may not mean it that way. So a lot of people say, I just said that sounds good to like be nice. But it gives that feeling of you saying, this is a good idea. That's right. That will work. And we want to avoid that. So be careful with that. Do you want to say anything about her leaving Wisconsin? This question, folks, is a little bit controversial, I'll admit, because it is talking about someone's specific situation. The reason why I got the green light here is it is just a question. We have to be careful because obviously I think there are situations where a question could be advice. Why wouldn't you ask for child support, you idiot? Your ex makes more than you do. So it's clearly going to work. I've sort of turned that question into advice. But if you're just clarifying something, so if somebody spent 20 minutes telling you about how their ex left Wisconsin, and then you reach the section where it says, why are you filing this motion? What is the change? And they say, well, it's a Tuesday. It's okay to say, do you want to say anything? Remember how before you mentioned that? Did you want to say anything about that? So it's not that you can never say anything specific to the interaction you're having, but you just want to be conscious and make sure that you're not pushing them into anything. But definitely, again, if they talk to you for a long time about something, you can double check and say, did you want to include anything about that here? That is okay. Here, I hope you get what you're asking for. That is one of those things where, again, this one, like the last one, little controversial. Some people could argue that's advice. But from my perspective, if you say you are going to get what you're asking for, that's a problem. That's advice. If you say, I hope you get it, I would argue that is you expressing what you want to happen, but not you necessarily saying what is definitely going to happen. Do I think you should be dancing on a line? No. But, if again, it comes up in a context and you say like, yeah, I hope so, I think that's different than saying, yeah, that's definitely going to happen. Down here, don't forget to write in your arrears balances before you submit the form. And people, again, are saying, what are you talking about? I wouldn't say that to every person who came through, but just a reminder of something you said. So if I said this in a different format, if I said, you need to write in your arrears balances before you submit the form, right? That's just information. And you go, well, but that wouldn't be the same for everybody. It kind of would be, because while somebody, maybe I helped them fill it out in the clinic, by helping them fill it in, we've covered that. And so that is something where it feels a little bit like it might be advice, because I'm saying, don't forget to do this. But it is ultimately just a reminder that they need to, hey, you need to write the arrears balances in this section before you turn in the form. So we just spent a lot of time on legal advice versus legal information. I hope that tells you how important this is to what we do in our clinics. It is one of the most important things, is making sure you are not giving legal advice. So if you take, well, there's going to be one other place where I'm going to say, if you take nothing else away from this training, take this. But legal advice versus legal information is key. It's a really tricky thing. I know sitting here, you're probably like, I got all of them. It's a slam dunk. I'm so good at this. But there are going to be times where it's such a fine line and it's so challenging. And so just be conscious about what you say, especially because if you make a mistake, you accidentally give advice and it's wrong, the client will never believe somebody who is telling them that what you said isn't right. Once somebody gets the answer they want, they just latch on to it. And so it takes a lot of work. As you will see, sometimes you'll deal with folks who've been given wrong information and are just clinging to it. So really important that we are giving correct information and that we are just giving information. We are not advising people. So very, very important stuff. Now, as part of our communication section, we're going to talk just a bit about terminology. So we have two sets of general terminology we're going to talk about. There are lots of terms we use in the forms clinic. These are really just like the highlights. These are the bare bones that you have to know to get by those first days that you're in clinic. And the first set of the first set of terminology we're going to talk about is post-judgment. So these are cases where clients have gotten some sort of order and now they're coming in and they're wanting to change something about it. These terms can, of course, come up in divorces too, but for the context of our clinic, they're a lot more common in the post-judgment forms. So I told you a minute ago that I was once more going to say, if you remember only one thing from the training, remember this. Now is the time. Here is what I'm going to tell you that, again, if you remember only one thing from the training, I picked this, but also remember legal advice and legal information. But again, this is really important. So in terminology, when we talk about custody in Wisconsin only refers to decision-making power. It has nothing to do with where a child lives, where they spend time, who they live primarily with, when they spend time with the parent they don't live with most of the time, has nothing to do with where they're located. Custody is just decision-making power. It's deciding where the child goes to school, who their doctor is, what religion they are, can they get married, can they join the military, all those sorts of major decisions that children or that parents usually make for their children before they turn 18. With this term, custody, it's really hard because clients aren't going to get it right. They're going to come in and they're say, I want custody of my kid. I want full custody of my kid. And your impulse is going to be like, oh, they want custody, they want decision making. But just like you up until a few minutes ago, our clients don't know that custody doesn't refer to where the child lives or spends time. So anytime somebody comes in and says, I want to talk about custody, you want to clarify whether they mean custody, decision making power, or whether they mean our next term, which is placement. So custody is decision making power. Placement refers to where the child lives and when they spend time with the parent they don't live with primarily. Sometimes clients will call placement visitation. It's part of my nitpicky nature to say, oh, that's not technically true because again, for our purposes, parents have placement even if they don't have that much time. So if I see my child every other weekend or I see them for 2 weeks in the summer, that's placement time, even though it's a very small amount. So custody and placement, again, these are very challenging terms for our clients. So you want to be really sure that you are clear on them because you're going to have to explain to folks when they come in and say, I want full custody. Again, anytime someone says, I want custody, usually your next response is going to be to say, okay, in Wisconsin, custody just means decision-making power. Do you want decision-making power, or do you want to talk about where the child lives, or do you want to talk about both those things? And sometimes students get really caught up in, because you'll have a client who will say, well, I think my ex's house is really dangerous. I just don't think that my child should be there. So I need full custody. I need to have custody. And you're going to say, custody refers to decision-making power. Do you want to be able to make decisions or decide where the child lives and who they spend time with? And they're going to say, I want custody. And a lot of our students will be like, oh, I guess they just want to talk about decision-making power. But often that is the client sort of expressing the term that they think describes what they want to do. And so you want to kind of push and say, okay, but just to be clear, do you want to make decisions or you want the child to live with you? And if they say, well, my ex's house is dangerous, blah, 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 you could try reframing it and say, okay, so what I think I hear you saying is you want to talk about you want to talk about the child potentially living with you and not being able to go to your ex's. Like, you want to keep going until you get an answer, because the impulse is going to be, well, they said custody, but remember, folks do not know the difference between custody and placement, so you're going to need to. So custody, decision-making power. Placement, where the child lives or spends time. Child support is probably a term you're very familiar with, and I have great news. Unlike custody, child support is exactly what you've heard. It is a payment, a court-ordered payment from one parent to the other to help pay for a child's basic needs. Food, clothing, shelter, that kind of stuff. In our clinics, we'll talk a fair amount about arrears. In some contexts, arrears can mean different things, but within the context of the MJC, arrears are almost always going to be back child support. So arrears happen if I'm ordered to pay $100 a month and I don't make that payment, I will eventually owe back amounts for the months where I didn't make the payment like I was supposed to. When we talk about arrears, there are two things we might be talking about. We might be talking about the arrears balances. So that is the total amount of arrears that a person owes. So if you think about it this way, again, I'm supposed to pay $100 a month, but I lose my job. And so for 6 months, I don't make any payments. I owe $600 worth of payments that I didn't make. That $600 is the total balance that I owe. It is my arrears balance. Arrears payments are how much a person pays each month toward the arrears. This could be different than their child support payment. So going back to my example, let's say I pay $100 a month in child support and I have that $600 of back amount. It could be that a court then orders me to pay $25 a month toward the arrears. So my child support payment is $100. My arrears balance is $600. And my arrears payment is $25. So the money that I pay toward the arrears balances is my arrears payment. And I know you're sitting here going, oh my goodness, do I need to know this? But it is important because we have different options depending on which thing the person is trying to deal with. Last but not least, sometimes folks are going to come in and say, I want to talk about taxes. Taxes can mean a lot of things, obviously, but within the context of the MJC, usually we are talking about who claims the child as a dependent on their taxes. So just like we have essential terminology for divorce cases or for post-judgment cases, we also have essential terminology for divorce cases. So some of those terms that you'll want to know are the terms Part 1 and Part 2. So these two terms are actually MJC specific terms. So what that means is if you have an attorney friend and you go out to them and say, hey, I worked on a Part 1 today, they may not understand what that means, even if they're a family attorney. That's because this is a term that we at the MJC use as sort of a shorthand to talk about the documents that are needed to start a divorce case. The good news is the courts are familiar with our terminology, so that's something that, say a judge or a court clerk would probably be familiar with, but an attorney not necessarily, a private bar attorney. So Part 1 is the documents to start a divorce case. Part 2 are the documents that you need to get your final court date in front of the judge. So here in Milwaukee, we break that process down. So you file the Part 1 paperwork, you serve your spouse, and then you file the Part 2 paperwork to get your final court date. The third important term for divorces is the dismissal date. So the dismissal date is unique to Milwaukee. I don't believe any of the other counties in Wisconsin use it. What a dismissal date is it's a deadline to turn in the Part 2 paperwork. So when you file your Part 1, the court gives you this deadline by which you have to turn in the Part 2. But what is tricky about it is it looks like a court date. Literally, the form says notice of hearing. And so it's really important to be familiar with the dismissal date because you're going to get people who you're going to talk to who you either need to explain the process to them or you need to be aware of it because they might be confused about it. They might say, yeah, I got to get this turned in. I have my court date tomorrow. And when you hear that should, your antenna should go up and you should be thinking, when you're saying court date, are we talking about the dismissal date? Are we talking about a pretrial date? What do you mean by that? Another thing that we'll talk about, both in divorces and post-judgment cases, but I think we talk about it probably a little more in divorces, is service. So in the context of the MJC, when we're talking about service, we are talking about a court-approved way to notify the other party about the case or an upcoming court date in the case itself. And it can be really tricky for our clients. So as attorneys, often you don't think that much about service, but for pro se litigants, this can be the hardest part of the whole case. And so you'll spend a fair amount of time talking about service. And when you're in the clinic, you want to make sure that you have a plan for service, that you are talking to your clients about how they're going to provide the other person with notice and making sure that they understand what are the court-approved ways to do so. Some people will say, I'm just going to take a video of it. Believe it or not, a video doesn't count. It's not articulated under the Wisconsin statutes. I would say I could be standing on the stage for the big New Year's Eve celebration in Times Square with Carson Daly, and I could say, by the way, here I am. I'm going to hand this to my ex, and the whole world can see it, and it doesn't count because it's not one of the ways that's articulated through the statutes. The last term here you'll want to be aware of is that term non-marital child. It refers to a child who is born to a female party in the case during the marriage, but that child is not the other spouse's child. That does come up from time to time in our clinics. The reason why it's important is the law assumes that your spouse is the other parent of any child born to a female party in a marriage. And so if the spouse isn't the child, well, hopefully the spouse is not a child, but if the spouse isn't the other parent for the child, we want to make sure that we know that, because they may have to do additional things to make sure the divorce court addresses that. And the last bit we have in our terminology is the actual forms themselves. So one of the things you'll talk about with the forms and how they're structured are captions. So the caption is found at the very top of a form, and it is a section that lists the parties. Often it lists their addresses. It indicates the name of the form itself and may give a very brief idea of what the form is. And it includes a case number. This caption is like a title page for the court. It tells them what case is this and what is happening in this case. On the opposite end of the form, so the caption is at the very top, at the very bottom you have a signature block. A signature block is a section where the person who is filing the form is going to sign and date. Again, this section typically includes the client's address, their email, their phone number. For some forms, it'll include their birthday. One of the things you'll learn as you're working on forms is you'll fill in as much of the signature block as you can. You obviously can't fill in their signature, and you often won't fill in the date, but you want to fill in, their name and address and things like that. The last thing you will find on some forms is a notary block. So a notary block is separate from the signature block, but it is a block of lines where when an attorney, not an attorney, well, it could be an attorney, when a notary notarizes a document, it is where they stamp and where they put their name, the date, and their signature information. You'll want to learn to keep an eye out for those notary blocks, because that will tell you if a document needs to be notarized or not. So now we're going to get into a little bit of the nitty-gritty of client interviewing. One of the things we have done to make client interviewing a little bit easier is we have provided something called fact-finding sheets. So when you're in the clinic and you're assigned a client, you're going to be given a sheet. It has the client's name and usually the client's birth date. And the sheet will tell you either it's a post-judgment case, a divorce case, divorce part 1, divorce part 2. It'll give you a little bit of information about what type it is, but it will also have some questions it walks you through about questions you want to hit in your interview with the client. So this is a guide to your conversation to make sure that you're gathering all the relevant information and identifying potential red flags. Always fill out the whole fact-finding sheet. Let me pause. Let me say that again. Always fill out the whole fact-finding sheet. It is one of those things where in the beginning, you're going to think, oh, I don't know if this is right. I'm not going to fill this in. I'm going to go ask a question first. And then as you get more experience, you're going to think, I don't need to fill this in. I have a shortcut to make it faster, better, easier. Please fill in the entire sheet. The only time you shouldn't be filling the whole sheet out is if you think you have the entirely wrong one. So if I gave you a part 1 fact-finding sheet and you sit down and the client says, I'm here to change my name, not get divorced, then you can come up and say you need a new sheet. But if you sit down and they say, I do want to do a part 1, and you're just like, oh, I don't think I need to fill out the rest of these. Resist that impulse, my student friends. Fill out the whole sheet. And another place where this comes up, the post-judgment ones, there's a little chart where you're going to put in the client's name, the other parent's name, the child's name. And people say, why do I have to do this? They gave me a case number. It's dumb. I want you to fill out the whole thing, right? The entire fact-finding sheet. We did not make these fact-finding sheets because we think they're pretty and they entertain us. We made them because they include the information that we need you to get. So even if you have a question, still gather this information because this information will probably help us answer your question. The other thing to know about the fact-finding sheets is you're always going to check in with the supervisor after filling it out. So that is how we help you analyze them to make sure that we are communicating the right things to the client about possible problems in their case. Things like that. So there is a video, a supplemental video, that goes through a fact-finding sheet and just shows you kind of what they look like and goes through them in a little more detail. Definitely take a look at that if you're interested. But otherwise, when you get into clinic, make sure you're filling out those fact-finding sheets and really just paying attention to them. When you're interviewing the client, when you're filling out the fact-finding sheet, and just generally when you're talking to the client, one of the most important things you're going to do is figure out their goal. When you come up to me as the supervisor and you say, well, I'm sitting with Mrs. So-and-so and here's what's going on, the first thing I'm going to ask you is, okay, what is their goal? This is one of the most important things to figure out. It is not as easy as it sounds, because sometimes you're going to sit with a client and they're going to say, I want to fill out this form. And you're going to be like, great, I know their goal. But we actually want to dig a little deeper than that. We want to know what they want to achieve. So if somebody sits down in front of you and they have a modification form and they say, I want to fill out this form, you're going to say, great, it looks to me like you have a modification. So that tells me you want to change an existing order and you don't think the other person will sign off on it. Does that sound right? And they're going to say, hopefully, yes. If they say no, then that's a new set of questions for you. But then if they say yes, because I want to find out what their true goal is, I'm going to say, okay, great. What do you want to change? Tell me a little bit about what you want to do differently about your order. Most goals that clients have are going to come down to one of four things. They're either going to say they want to get divorced or a legal separation. They're going to want to change their name. They want to change an existing order, or they want to enforce an existing order. And again, sitting here watching this video, that seems, I'm sure, very simple. You're like, yeah, no problem getting it whittled down to those things. But it really is a bit more art than science. It can be a struggle to narrow it down to one of those four things. But that's always your goal. In an ideal world, you want to be able to say, they want to change their child support order. They want to enforce their placement order. But when you get started, even if you can't whittle it down to one of these, if you come up to a supervisor and say, well, he hasn't been able to see his child for several months, and he wants the other parent, the mom, to let him see the child. You haven't necessarily narrowed it into one of these categories, but you have determined his goal, and with that information, the supervisor can help you get it into one of those categories. One of the skills you're going to use in the clinics is active listening. So when you're active listening, your goals are to build rapport and trust with the clients, which is great. Again, you're going to spend the bulk of the time with the clients. You're going to be the person who they know and like and feel like they trust, and active listening is a part of that. The other goals, we want to make the clients feel heard and understood. One of the really challenging things about the courthouse is that clients feel like nobody listens to them. They go to a room and they say, here's this horrible thing that's happening in my life, and the people say, here's a paper, please leave. So we want to make this a space where clients get to feel heard. Obviously, somebody can't talk to you for 7 hours, but we do, want to let them get their story out and feel like you understand them and that you care about helping them with their situation. Another goal of active listening is it's a great way to help us obtain the information that we're going to need to figure out what form they need and to fill out the form completely. Because that's what all of this training, again, we are over an hour into the training and I have not even yet showed you a form. That's because all of these other skills are super important to our ultimate goal of identifying the form and filling the right form out completely. The last thing is active listening can help us identify potential problems in somebody's case. So some techniques you might use for active listening, restating or summarizing. So that's where you're going to give the client back a brief recap of what they told you to make sure you understand, right? So if I understand you correctly, you're saying that your ex hasn't let you see your child in several months and you would like to be allowed to see them or to have a specific schedule. Yep. If I'm understanding it correctly, you said that you want to be able to make decisions about where your child goes to school. It sounds like you want to change your child support. Two sort of helpful parts about this. First of all, if you're correct, it helps you connect with the person. That's right, they hear me, they got it. If you're wrong, it can be a place for the client to say, no, that's not right at all. So if I say, if I understand it correctly, you want to talk about where your child lives, and they say, no, I want to talk about child support. I know that I've misunderstood something, and I can say, okay, let's go back. Tell me a little bit more about what's going on. So it's a really great way to make sure that you are getting all the facts right. Another thing you can use when you're active listening are encouragers. And the great thing is, I think most people use these encouragers just naturally. But that's where when someone's talking to you, say, okay, yeah, and then what happened? Oh, I understand. Tell me more. Oh, okay, yeah. So it's just those natural punctuations of conversation where you show that you are listening to somebody. Oh, okay, yeah, I'm hearing what you're saying. It's sometimes questions to keep them going. And then what happened? Or what did she say? Just things that sort of, they let them know you're listening and encourage them to keep going and giving you the information they're giving. And again, some of these techniques you're going to do naturally. So don't feel like you have to be like, oh, and now I need to say okay. Some of this is just stuff you're going to do. And if you find you're not doing it, you can incorporate it into your presentation. Your presentation to clients, it's not a presentation I'm going to make you give. Emotional labeling, that I will admit is probably my weakest suit, but it can definitely work for some folks. So that's where it sounds like you're feeling frustrated. That sounds really difficult. Well, I guess that sounds really difficult. It's probably more validation. But emotional labeling, where it sounds like you're feeling frustrated. It sounds like you're feeling really sad that you can't see your child. It's a way to connect with the client. And hopefully, again, if you accurately reflect back what emotion they're feeling, it can be a way to help connect with them, make it clear that you are listening and that you get it and that you can hopefully help them. Validation, again, you have to be careful because it's not you're going to get what you want. That's legal advice. But that sounds frustrating. I get that must have been difficult. Yeah, that sounds like it's been really tough. It's just, again, kind of validating their feelings, saying, yeah, it sounds like that has been difficult, challenging. It's okay to feel that way. You want to be careful here because you obviously don't want to sound fake, That sounds really tough. Anyway, back to what I care about. It's you want to be truthful and people can tell, sometimes when you're being fake. But, it can be something where you're saying, yeah, it does sound frustrating. Definitely validate that, and it can be a way to connect with folks. Some techniques that work for active listening are open-ended questions. So if you have somebody who's really shut down, I just want to fill out this form. Yes, no, yeah. Sometimes asking open-ended questions can get you a little more information. What do you think would happen if you mailed it to her house? What sort of schedule do you want when you're, do you want to keep to see your child? It can be a way to get a little bit more information from somebody. And last but not least, redirecting. Sometimes you're going to have a client who's going to talk a fair amount. One way to sort of get them back on track is let them talk a little. Again, I think sometimes people just need to blow off steam. But after it's been a bit and you're starting to get off topic, or you're really wanting to get them back to the form, as much as you can, I get how frustrating that might be. Let me ask you a couple of questions so we can get started on this form and you can get a court date to try and change your order, right? So you are validating. Yep, that sounds really difficult. And then you're redirecting and going, let's get back to the thing. Let me ask you some more questions so that I can get you through this form so that you can go get your court date. Like, let's make some progress. Within client interviewing, you'll also want to be conscious of your non-verbal listening skills. So making eye contact. Again, that's not one I myself am great at, but you want to make eye contact with people to help sort of, let them know you're listening. Mirroring, again, these things can be challenging when they're new to you because you don't want it to seem forced. But mirroring someone's posture, if they're sitting forward, if they're sitting back, that can help people feel a sense of connection. You can use gestures, right? You nod at someone, you smile, maybe you talk with your hands. Those can be some nonverbal ways to show you're engaged in the conversation. And then just avoid distractions, right? Nothing is going to make a client feel less important to you than if you immediately check your phone every 2 seconds while they're talking to you. The other thing to know is there may be distractions the client has, and there's not always a lot you can do about that. They may have children with them. They may have what we call co-pilots. That's where they've brought a friend or a family member who is, they mean well. They're here trying to advocate for their friend or their family member, but sometimes they can be a distraction because they're taking the conversation away from where you need it to go. And last but not least in this video, follow-ups and redirect tips. So again, sometimes there are going to be situations where you ask a question, a brilliantly worded question that you're very excited about, and the client just goes, nah, right? So where they don't give you the kind of information you need, or you need additional information, or where they're sort of veering off topic. And so some things you can try with that. Again, if a client says they want to fill out a specific form, I just want to do this form. You can try explaining what the form does and sort of confirming what they want to get out of it, right? So, great, that looks like a stipulation form. That form is used to change an existing order when you and the other person agree and will both sign the form. What do you guys want to change with that form, right? So I have followed up my original question and I'm leading them to hopefully give me more information. As I mentioned before in the custody section, when somebody says they want to change or enforce custody, your immediate follow-up should be like, great, here in Wisconsin, custody means decision-making power. Did you want to change decision-making power, where the child lives, or both of those things? Because we really want to clarify and make sure that they don't mean placement, because a lot of times clients are going to mean placement when they say custody. If the client is telling you that long sort of not really on topic story, again, that's where you might redirect a bit and say, again, you validate, that sounds frustrating, let's get back on track so that we can get you into court so you can resolve that issue. All right, well, that is a little bit about all of the client interviewing and client communication. I will see you guys for the next video where we will finally get into the clinic processes and the forms themselves.